Good afternoon, everybody. My name is Jason Killeen, and I'm an Assistant Executive Director with the Department of Cannabis Regulation. Today is going to be a special edition of our monthly question and answer virtual lunch. Today, we're briefly going to go over the 2025 license renewal process. Our license renewal period is going to open on Monday, September 2nd, and the initial license renewal phase will run from September 2nd to November 1st, 2024. The municipal code was updated a few years ago to allow for folks to submit late renewals. The late renewal period starts on November 2nd. Late renewals, of course, are subject to additional fees. Our regular renewal period runs from September 2nd through November 1st of 2024. We have two late renewal periods. The first late renewal period runs from November 2nd through December 31st, 2024. After 11:59 p.m. on December 31st, all licenses expire. So if you have not timely renewed your temporary approval and annual license or annual license by that date, you are no longer allowed to operate on January 1st of 2025 until such time you actually renew your license. So if you fail to renew between the regular and the first late renewal period, you must cease operations beginning January 1st until you come back into compliance. The second late renewal period affords people an opportunity to basically resubmit their renewal application and go back through the process. If you fail to renew by February 28th of 2025, your record will need to be refiled. And that means you have to restart the entire application process, starting with pre-app. So if you fail to renew during one of the articulated renewal periods, you would have to utilize the refiling process and start back at the pre-application process, which may allow for a competitor to potentially move into your buffer zone or your previously occupied buffer zone. Late renewal applications are subject to additional fees. So it is very important for folks to get their renewals in during the regular renewal period, which runs from September 2nd through November 1st. All records are required to submit an updated legal business entity record disclosure form, which is our LIC 4008 form. You must submit an updated indemnification agreement, which is our LIC 4005 form. For social equity records, if the social equity individual applicant has not already submitted a successor and interest form, which is our LIC 4018 form, you'll have to provide one. Those forms can be uploaded to the legal business entity record. So as we start to review the renewal records, we will be checking if it's a social equity one, to see whether or not a successor and interest form is on your legal business entity record. If it's not, you will be asked to submit one to the legal business entity record. For number 4, you'll have to provide an updated copy of your business premises diagram. There's additional requirements that our Compliance and Enforcement Division are going to require for the 2025 premises diagram. And that's all leading up to folks being able to basically pass the final inspection and be issued operating permits, hopefully sometime in calendar year 2025. Folks will need to upload evidence of site control. So if you have an active lease that covers the period in calendar year 2025, you can go ahead and upload that copy. If your lease is going to expire before the end of this calendar year and you're in active negotiations, that's okay. If you've gone month to month with your landlord, that's okay. But we're going to need to have some evidence uploaded that you will be able to continue to operate at your current location or occupy your current location in calendar year 2025. And then the last big piece is payment of the renewal fees and any previously deferred fees. So we've started to invoice folks for the deferred annual license application fees. Regardless of when you get that invoice, it will be due by, on or before December 31st of 2025. So if you fail to pay those previously deferred fees, that is a reason to deny your renewal application, and we will be denying those renewal applications and abandoning records where applicable fees have not been timely paid. We will be sending out an email communication about the renewal notice and the reminders with slightly more detailed instructions on how to renew. Records that have a status of local compliance underway or temporary approval that have not been granted an annual license will renew against their A&N record. And then for folks that have received their annual license, we will be creating annual license records, and you will go ahead and renew against your annual license record. As we transition folks from the A&N process, which has two different decision makers, the Cannabis Regulation Commission approves annual licenses for the Type 10 retail storefront activity, and then the director has the authority to grant annual licenses for all other activities. Once we've issued the annual license, when we create your annual license record, the suffix for that record will be LIC. We will be putting all of the activities on the same record, so you'll only have to renew one record at that point. So as we start to get more annual licenses issued, we will be migrating folks from the A&N process to the LIC process for the issuance of both licenses as well as for the payment of invoices and fees. In terms of the renewal fees, this is going to be the first year where we'll have all three of the renewal fees in play. The record renewal is for annual license applications that have not received temporary approval yet or received an annual license. The record renewal fee is $1,829. If it's paid during the regular renewal period, it increases to $2,598 if it's filed between November 2nd and December 31st. And then it goes up to $3,464 if it is not filed until January of 2025. And of course, the last day to submit the late renewal is February 28th of 2025. For temporary approval renewals, the renewal fee per activity is $4,233 if filed between September 2nd and November 1st. Then it increases to $6,013 per activity, and then it goes up to $8,016 per activity if it's filed during the late renewal period. And for folks that have received their annual license, the renewal fee is $8,486 per activity. If a late renewal is submitted, it goes up to $12,054. And if late renewal is submitted, it goes up to $16,071. All of these renewal fees are set by code. For the renewal record, those are the a la carte fees for the documents that are required as part of the renewal process. It does not include any inspection fees. So if you do get temporary approval between the renewal period and the end of the calendar year, you would be subject to the standard inspection fees for your activity in 2025, which would be invoiced separately. And with that, we can go ahead and hop into any questions that were submitted or may have come in during this special event.
Good afternoon, Jason. Our first question comes from Mary S. When is the next cultivation and retail storefront lottery?
We don't have a date for that yet. We are going to be transmitting a report for City Council consideration next month. And as soon as the policymakers have an opportunity to consider that report, and if they act on it, we may have a firmer date on when we would be able to open up those lotteries.
Thank you. From Derek L. What are the next steps for cultivation licenses and temporary approval?
So We are beginning to invoice for the annual license application fees for the non-retail activities and for the Type 9 delivery activity. Once the annual license application fees have been paid, we'll begin processing those non-retail annual license applications. And, once staff have completed their review, if you've met the requirements, DCR would take the action to grant the annual license.
Our next question also comes from Derek L. We have not received an inspection notification yet. When should we expect that to happen?
It's going to come down to where you're at in the process. If it's the same Derek L that asked the prior question, you have temporary approval. The Compliance and Enforcement Division has been prioritizing the compliance inspections for the retail storefront type 10 holders because those go through the Cannabis Regulation Commission. But they are beginning to do non-retail compliance inspections. So be on the lookout for the inspection team to reach out. If you have not received temporary approval, then the onus is on the applicant to work with their analyst to request an initial inspection. If you have an application that would otherwise be eligible for temporary approval, if you have a state provisional license.
Josh E. asks, will DCR renew licenses of companies that have not yet paid their city taxes?
If a business is not in good standing with the Office of Finance because they're delinquent with taxes or other city fees, that is a reason to deny the renewal application. The Office of Finance will send us a list of businesses that are not in good standing. We will forward that information on to the businesses to let them know that we've been notified that your business may not be in good standing with the Office of Finance. And then it will be up to the business to reach out to the Office of Finance to address whatever the issue is. And then finance will let us know whether or not you continue to be not in good standing. And, if you're not in good standing, that could result in the denial of your renewal application. But the onus is on finance to report non-compliance or a business falling out of good standing because we don't have access to, of course, the tax rolls associated with each business.
Thanks, Jason. Our next question comes from Ariella J. Do you know when the next batch of notice of exemptions will be uploaded to the SequentNet website?
I want to say that everything that has gone through the Cannabis Regulation Commission through August 1st will be up on SequentNet by the end of this week. I haven't looked at our tracker in the last couple of days, but I know the person who has been uploading them was on track to get them all uploaded, but I think most of them are there now. And we are starting to have DCR staff upload the state clearinghouse numbers and the packages to the box.com account that DCC had set up to hopefully streamline the process a little bit to help folks meet the requirements to get their state annuals. So I would double check SequentNet. If you don't see it on SequentNet, reach out to your analyst and your analyst can, follow up with me and we can get you an update on where your OPR filing is. And, again, that's everybody who has gone through the commission as of August, on or before August 1st. We're still working with the city attorney's office's doc services for all of these categorical exemption filings with the county clerk for the records that were approved by the commission on August 15th. And as those come back on a rolling basis, we'll start working on the OPR documents. But I did pull up my tracker, and there's 141 records on the tracker that have state clearinghouse numbers now. So again, anything that went through the CRC by August 1st should be up there now. And if it's not, it's just because we haven't gotten the filing back from the county clerk through city attorney's doc services group.
Our question from Sharam T. Are license renewals yearly?
Yes. Records and licenses must be renewed on an annual basis. All local records and licenses expire after 11:59 p.m. on December 31st and will show an expired status if not timely renewed.
Joel G. asked, when will I be able to apply for a storefront license, and do I have to apply for distribution license as well?
If Joel G was selected as a social equity individual applicant as part of phase 3 retail round 1 or phase 3 retail round 2, and you haven't already submitted your type 10 application or received a type 10 license, you would be able to, if you're looking to get verified or participate in a future lottery for the type 10 retail storefront license type, we don't have a date for that at this time.
There was also a question about application for a distribution license, if there's an application for that.
The distribution activity, general applicants and social equity applicants can apply for that activity through the DCR licensing portal. So we are accepting distribution and distribution transport only applications at this time from all applicants.
Thanks, Jason. Moving on to Terrence R. Many of the owners and investors of our phase 2 business live out of state. Can the company's authorized agent sign all of the renewal forms on the company's behalf, or do we need to have our investors visit California?
The forms indicate what the signature requirements are. If you have an authorized agent form on file with DCR, generally the renewal forms and documents can be signed by the authorized agent. Generally, the only time an authorized agent can't sign a form is when the form requires the signature of the qualifying social equity individual applicant on the account, and or you have to have a simple majority of the owners, or if the form itself is tied to an individual person. But most of the forms can be signed just by the authorized agent.
Got it. Our question from Josh M. What are some of the common mistakes or issues you see with renewals?
The common issues are folks uploading old documents. It's important for you to make sure that you're using the most current versions of the forms. For instance, we used to have 2 ownership and primary personnel disclosure forms, the 4003 form and the 4008 form. So we've collapsed all of those into the 4008 form. So if you're submitting an old 4008 form, it's going to be missing information. Another common mistake is just folks uploading incorrect forms or uploading them to the wrong place. And then, of course, it is important to make sure that you're actively renewing all of your active records, because each of those active records is a distinct record that has to be renewed. So you can't assume if you have a retail storefront record and you have a non-retail record, that by renewing one of those records, you've met the renewal requirement for both records, because that would not be the case.
Our next question comes from two individuals, April D and initials JG. How do I get started in the cannabis business and what licenses are needed?
So I would recommend doing just general research on the types of activities you want to engage in so that you have an understanding of the local licenses as well as the state licenses you would have to pursue. For the general information about DCR's processes, it's available on our website under our licensing information section. So it talks about the application procedures, it talks about the different activities that we license. The Department of Cannabis Control, which is the state agency, also has a website that has a lot of information that ties to their license types. We do have information and brochures on our website tied to starting a cannabis business and what you have to do with the California Secretary of State to, open a business and get it registered. The first step is the applicant that's going to be applying, whether it's an individual or a business entity, you're going to have to make sure that you're properly registered with the Secretary of State as well as our Office of Finance before you can even submit a pre-application or a commercial cannabis application. So making sure that you start your business properly, you register your business with the necessary parties would be step one. And then step two is really what activities do you plan to engage with in making sure that you apply for the corresponding licenses at the local and state level.
Our next question comes from Rakija M. Why are the fees different between social equity applicants if they are getting the same license?
Social equity applicants have to go through the equity share review. So that requires DCR personnel to look at operating agreements, to look at the voting rights tied to each of the members of the agreement to make sure that the social equity individual applicant has at least the voting rights commensurate with their equity stake in the applicant. There's also required language that has to be included in the agreements as mandated by the LAMC. So even though you're applying for the same activity to participate in the social equity program and get a social equity license, there are additional requirements. And of course, because those additional requirements create an additional cost for the department staff-wise to do this additional review, that cost is, of course, passed on to the applicant. DCR's mandate is to be full cost recovery, and we don't get a general fund subsidy to basically waive or otherwise offset the additional costs of administering social equity applications or social equity licenses.
Another question from Rakija. How can the city help with our application process?
The city has a number of tools available on our website to help folks understand the application process. Verified social equity individual applicants may have access to different social equity programming, such as pro bono, low bono legal services, one-on-one coaching. If you are a verified social equity individual applicant, you can reach out to the social equity team to see what services may be available to you. But the city nor city staff will actually sit down and process the application and fill it out for you. So, you'd have to submit your application and then meet the application requirements on your own. Again, there may be resources available to you if you are a social equity individual applicant where a lawyer or consultant could assist you in setting up the application or submitting documentation, but that would not be something city staff would do.
Our next question comes from Joanne D. What happens if you don't connect or appear before your neighborhood council?
Two different things there. So businesses that are applying for the type 10 retail storefront commercial cannabis activity are required to go through a community meeting and public hearing process. As part of that process, when they receive their notice of complete application, the code requires them to reach out to the neighborhood council and offer to meet. So as long as you've offered to meet with the neighborhood council, you've satisfied that requirement. The municipal code does not require you to appear before the neighborhood council. But that is all, of course, something that the Cannabis Regulation Commission can take into account as they review your application records, community input, and stakeholder feedback. So failing to contact the neighborhood council could result in the denial of your annual license. But that's not a decision the department makes. That's a decision that would be made by the Cannabis Regulation Commission.
A follow-up question from Joanne. How do you get a cultivation license and can I buy into someone's existing license?
We're not currently accepting applications for the cultivation activity. If one of our existing licensees, if somebody's selling equity in the license or they're looking for additional capital and they're issuing shares, you may have an opportunity to buy into an existing licensee. We don't do any matchmaking, and we don't make any business recommendations. If you know existing cultivation licensees, you could reach out to them to see whether or not anybody is looking to sell equity in one of those licenses or if they're looking for additional financial partners. But an ownership modification would be the ultimate mechanism if you were being added as an owner of an existing license.
Our next question comes from Al V. Regarding fee waivers and deferrals. Is it foreseeable that there will be available funds soon through the city or the state? And if so, can we apply these funds to annual renewals due in 30 days?
The simple answer is going to be no. So we do not have fee waiver monies available for any of the renewal fees, and the renewal fee period is set by statute. So there are no deferrals beyond what's in the statute. And if you don't renew during the regular renewal period, there are additional costs that will be passed along if you file a late renewal.
A question from Jorge B. We have our annual application in, but the business is not currently operational. How does this impact our inspection?
The annual application status doesn't impact the inspection. What impacts the inspection is whether or not you've been issued temporary approval. So applicants that don't have temporary approval are not allowed to operate. And, we're not going to schedule an initial inspection to grant temporary approval until the business has met the requirements for temporary approval. And then, of course, you're not eligible for a compliance inspection until you have a license in some form and fashion. So if you're not operational and you don't have temporary approval, you're not going to be scheduled for an inspection.
Our question from Orlando P. Will DCR still be able to waive annual license fees, and does the state still have a waiver in place?
Yes and no. We have the Cannabis Equity Grant, or CEG grant, from GOBAs. Some of those monies are earmarked for phase 3 retail round 2 applicants. Each of the folks that were selected through the lottery in December of 2022 got a prorated amount of CEG grant monies to apply towards application fees. Depending on what services those applicants got, any surplus in the account may be applied towards the annual license application fee. But those grant monies weren't sufficient to cover the pre-app, the equity share review, the legal business entity record, and an annual license application. So at some point, the applicant would have to pay for some services. Um, Additionally, some of the newer money we have is only eligible for the type 10 activity. So if you have licenses for cultivation, distribution, manufacturing, you would have to pay those annual license application fees. We're still working with the state as it relates to the local jurisdiction assistance grant on getting approval for what fees those grant monies can be used for. Those grant monies cannot be used for annual license application fees. We may be able to use them for notice, community meeting, our environmental review fees, but the state hasn't actually approved any direct fees from that pot of money yet. So there may be some fees that could be waived. Not all fees will be waived, and most applicants are going to have to pay all of their annual license application fees.
Our next question from Angelo S. What if we were in phase 2, but were not chosen in the retail license application selection process, and then the rules were changed? How do we know if our name is still on the list, or do we need to reapply?
If you were not selected through the phase 3 retail round 2 lottery, you were not eligible to submit a type 10 application. There were only 100 individuals who were selected through the lottery to have the opportunity to submit the type 10 application. So if you applied and you were not selected, you are not eligible to submit an application.
Our next question from Victor G. What are the renewal fees every year after you get a license? Do the fees get waived if you are on the social equity program?
The fees are set by code, and let's see if I can. The annual license renewal fee is $8,486 per activity. The fees do not get waived if you are part of the social equity program. The only time the fees could be waived is if we got a general fund appropriation, which we don't have right now, or we're awarded grant monies from the state where those monies can be used to waive renewal fees.
Question from Paula B. What are the next steps for phase 2 non-retail licensees with temporary approval that need to secure annual licensure from DCR in order to transition their provisional state license to annuals prior to the DCC cutoff date?
Folks will be receiving an invoice within the next 30 days for the cost of their annual license application fees. And for social equity applicants that haven't gone through the equity share review, you'll have to pay your equity share review fees. For tier 3 applicants in phase 2, you'll have to submit your social equity attestation that you are compliant with the requirements of being a tier 3 person in order for your application to be deemed complete. Everybody's going to have to pay those fees, and then we'll start to process those annual license applications as soon as the fees are paid.
This is a follow-up from Paula B. When will phase 2 non-retail licensees be receiving notices of determination, CEQA exemption documents from DCR?
So again, for phase two folks, your applications will not be processed until the annual license application fees have been paid. You won't get a notice of complete application until you've either completed the entire application process and the equity share review if you are applying as tier one, tier two, or you've paid your fees, completed the application process, and submitted the tier three social equity applicant attestation form to meet the requirements as a tier three applicant. Once you've been issued your notice of complete application, staff have time to prepare the staff report and then present it to the director for approval. And part of that staff report would include the environmental analysis, which may result in you being determined categorically exempt from CEQA. And if we make that determination, we determine that we're going to issue an annual license. Then and only then would we file the categorical exemption with the county clerk, which then will get you the environmental document that the state wants.
Question from Philip A. What is DCR's position on the process of a non-social equity applicant purchasing a license from a social equity applicant?
The municipal code does not allow for a social equity license to be converted to a non-social equity license at this time. And we only consider ownership modifications of licenses, not applications. So a non-SEIA cannot purchase equity in a social equity license such that it no longer complies with 10420. That modification would be denied.
Question from Renee E. I was told retail licenses now will need a health department certificate by the end of the year. I was also told that without a certificate of use permit by building and safety, I cannot even apply. Since that step can take more than a year, what happens if I don't meet the deadline?
So that is not a new requirement. The municipal code has required for several years that type 10 license holders need to get their public health permit by January 1st of 2025. We had worked out a process for existing licensees to go through a streamlined process with the Los Angeles County Department of Public Health, and unfortunately, a lot of licensees did not participate in that process. To comply with DCR regulations, the code does require you to have that public health permit by January 1st of 2025. And it assumes that you would be required to stop operating if you have not received that permit. DCR, as part of our September report, is seeking council approval to extend that date, provided the licensee has initiated the process and started it, which may be met if you have started to work with building and safety or other regulatory agencies to meet the requirements to get your health permit. But that is a recommendation to the city council. It is not local law. So if the law is not amended, if you have not gotten your health permit, you would be required to cease operations until you get the necessary public health permit.
Let's see, this is a follow-up from Renee. Please specify how one would obtain a health department certificate without waiting a year from building and safety. And I was told I need to hire an engineer, architect, et cetera, to even get that started.
These are permitting processes outside of DCR's control. The public health permit is issued by the Los Angeles County Department of Public Health. As part of their process, they require you to obtain all necessary clearances and permits from different regulatory agencies, which includes the Department of Building and Safety. Part of that building and safety clearance is looking at the certificate of occupancy that was issued and the type of permit that you're seeking. So if you purchased a plot of land that was used for automotive dismantling, and that was the certificate of occupancy tied to that building, that certificate of occupancy does not align with the retail storefront activity. So you would have to go through building and safety's permitting process to change the certificate of occupancy from automotive dismantling to retail or whatever other commercial cannabis activities were going on there. You know, the process is building and safety issues those permits, they review those requests, and all applicants and licensees have to comply with not only local and state law as it relates to commercial cannabis activities, but you also have to comply with all other building code, fire code, public health code, and other regulations tied to the parcel of land you're operating on. For questions about the public health permit, I recommend reaching out to LA County Department of Public Health. And then for questions about, changing your certificate of occupancy or permitting requirements you may need to meet, reaching out directly to the Department of Building and Safety to see what you would have to do to comply. Unfortunately, we have no role in those regulatory processes, application review, permitting processes, nor do we have the authority to direct either of those agencies to grant or issue a permit or circumvent their processes. So, I'm sorry, that's probably not the news you were expecting to hear.
Thanks, Jason. Angelo S. asks, what if during the first verification process we were not picked as part of that selection process? Are you still recognized as a verified social equity applicant, or do I need to get verified again in the next round, being that I'm already a phase 2 applicant?
It really depends on what activity you're applying for. If you've already been deemed a social equity individual applicant, the application types that you've already applied for, your status stays with those applications. For the retail storefront lotteries, council determines what the criteria are to participate in those lotteries, and that may or may not require you to get re-verified. So I would just stay tuned and wait to see what policy decisions are made. And then that will really drive whether or not you would have to seek verification again when that process reopens.
Our question from Ron. Can DCR provide the contact information for the community liaison for each location?
For the retail storefronts, they should be posting their neighborhood liaison contact information at the store location or providing it to you. We are working on updating the DCR licensing map to capture that information as well. But if they have not provided that contact type to the department, we wouldn't have it on hand. You would have to go to the location to get that information.
Thank you, Jason. Moving on to Ariella J. For renewals, you stated that an updated license 4008 form is required. Are updated license 4004 forms also required?
No, just the documents that are on the screen right now are required for this renewal process. If you need to make amendments or modifications to other forms and documents, I would just recommend following the department's normal modification process.
A question from Bertha S. What should we focus on in regards to secret review when applying for a license?
Uh, the department has the LIC 4013 form that has a series of questions that applicants need to complete, and that becomes the guiding document as we do our environmental review. And then depending on how you complete that form and what your responses are, it gives us a general idea of whether or not your project may qualify for a categorical exemption, or we may have to move on to an initial study and a more involved environmental analysis. So please take a look at the 4013 form, which is available on the DCR website.
A follow-up question from Bertha. Why does the environmental review include a question about consumption, power consumption by the previous renter?
Because some of the categorical exemptions are tied to the prior use of the facility. Things like retail activities, whether it's a cannabis business or, um, you know, a business selling shoes or clothing, they're probably consuming a similar amount of power to keep the lights on and the displays. Versus if somebody was selling clothing and that location was being converted for cultivation or nursery activities, those activities may consume more power. So it's really to do a comparison to see whether or not there's impacts between the new use versus the old use. And again, there's other things that tie to what the building has been issued a certificate of occupancy for, the historical usages, and then what activities, were going on at the location and how long.
Question from Darwin B. Why does DCC not recognize the ice cream truck model of delivery?
That would be a great question for the Department of Cannabis Control. The state is the lead agency when it comes to regulations and everything else. Like, folks have to comply with state law. So if it's something that the state does not recognize or allow, basically their application of their law and their regulations will drive, what DCR can consider lawful within the city. But if you would like to, advocate for the ice cream truck model, you'll have to do that with state regulators first.
Our next question comes from Justin P. There is an invoice that I was asked to pay but didn't get to operate. Can I get a deferral? I am social equity.
You would have to talk to your analyst. DCR has deferred the annual license application fees for over a year for all applicants. So most applicants who had temporary approval were migrated over to the annual license process in May of 2003. And then folks that did not have temporary approval were migrated over in September of 2003. And, those fees were deferred because, we were hopeful that LJAG funds could be used to offset those costs. Unfortunately, that's not the case. We had been issuing notices of complete application based on deferrals just to get the ball rolling. And, the state has definitively said what's eligible, what's not eligible, which are those annual license application fees. So, they do need to get paid. And unfortunately, even if you were to receive a deferral, DCR is not going to process your application until the fees get paid. So a deferral would just result in DCR not taking any action or activity on your record until the fee got paid. You can reach out to your analyst to see if your record would be eligible for a deferral. But again, the deferral also results in the application not getting processed. It's just granting you an additional period of time to pay.
Jason, I wanted to check on your time. We have 9 minutes left in this webinar and about a dozen questions to go.
I will talk as quickly as possible to get through as many questions as possible.
I will too. Diana E., is there a deadline for phase 3, round 2 applications to submit a pre-app?
Yes. December 2025.
Follow-up from Diana, is there a limit for phase 3, round 1 to submit pre-applications?
Phase 3, round 1 originally submitted an application. If that application was abandoned, the refiling process allows for it to be refiled once within 3 years. But a refiled application may not be further refiled. Round 1 is really more record specific, and you would have to reach out to the analyst to determine whether or not the record is eligible for refiling in the first place.
Diana E. also asked, can the applicant submit a modification request for ownership change if the applicant has not received temporary approval yet?
No, we would not consider an ownership change during the pendency of the application. Like, we would cease processing the application, and it may have to be withdrawn, canceled, or abandoned to make those necessary modifications prior. Again, that's a more record specific question where you'll have to reach out to your assigned analyst and give them the record number so that they can look at the specifics. But we do not process ownership modifications on pending applications.
Again from Diana, applicants who have state provisional licenses and have not received their annual license or final CEQA docs, how can they proceed with renewing their state provisional license?
You would go through the state agency. I would recommend reaching out to the Department of Cannabis Control. State statute only allows for those provisional licenses to be renewed in calendar year 2024, and DCC no longer has the authority to renew existing provisional licenses beginning in 2025. And then, there's caveats for different activities. With Senate Bill 51 being adopted, the state has authority to issue new provisional licenses to social equity retail applicants, type 10, type 9. But those are all questions that should be targeted towards the state because it's related directly to their process.
Next question from Ignite D. What will happen to social equity applicants who are still in review status come 2025?
It's going to depend if the application fees and renewal fees are timely paid. The record would convert over for 2025. But if the applicant is not able to meet the application requirements to get a notice of complete application, the record's going to ultimately be deemed abandoned.
Question from Ignite again. We have an application that has been in environmental review. When will we receive an email from DCR regarding it?
It's going to depend on the record type. If it's a type 10 application, we may be working on the environmental review. If it's not a type 10 application, we won't begin the environmental review until those annual license application fees and other corresponding fees have been paid.
From Rick J. I have a micro business with no retail activities. For the annual application, may use the non-retail process.
DCR does not issue a micro business license for like the state does. So the Department of Cannabis Control will issue a micro business license when the applicant is engaged in 3 or more commercial cannabis activities. At the local level, you have to apply for each activity separately. So if you had three non-retail activities, cultivation, distribution, manufacturing, at the local level, you would pay the annual application fees for each of those activities. And then at the state level, you may be eligible just to apply for a single micro business license. But at the local level, again, we don't issue a micro business that captures multiple non-retail activities. You have to apply for and pay the fees for each activity separately.
NARIC B, if the license record status is still temporary approval, when should we anticipate receiving annual?
It's going to depend on the record type. And again, we've started to issue the annual license application invoices for outstanding annual license application fees that we know won't be covered by the local jurisdiction assistance grant. And payment of those fees is required to get to a notice of complete application.
From David P, we are phase 3 retail. Can we receive our provisional from DCC and get temporary license from DCR to go operational without having a community hearing?
The Department of Cannabis Control has the authority to grant provisional licenses to social equity retail applicants. If you do get your provisional, you may be eligible to request an initial inspection. And if you pass the initial inspection, be granted temporary approval. Temporary approval does not require a community meeting. So you can go operational through a temporary approval without a community meeting.
Again, from David, what is the DCR timeline for the temporary approval after receiving the provisional from DCR?
In order to get temporary approval, you also have to pass the initial inspection. So I would reach out to your applicant or to your licensing analyst if you haven't already passed an initial inspection to schedule an initial inspection.
Jason, can you do 3 more questions?
Yeah, I can.
Okay. From Anahi, do applications with local compliance underway need to submit renewals?
Yes. Records have to be renewed on an annual basis. Records with local compliance underway pay that initial $1,829 renewal fee per activity.
Steve B, will the January 1st, 2025 emblem program requirement be postponed?
I don't know. We're going to submit a proposal for council consideration to amend that language to make it the latter of January 1st, 2025, or folks navigating through the emblem permitting process. But as it stands under current law, January 1st, 2025 is a hard deadline.
And then final question from Ernesto G. I was in the retail lottery round of December 22 and was not selected. Can I enter the next retail lottery round?
City Council hasn't adopted the criteria for the next retail lottery yet. So ultimately that policy decision would determine whether or not you would be eligible to submit an application to participate in the next lottery. So stay tuned.
That was our final question. Thank you, Jason.
Thank you. Our next Q&A virtual lunch is going to be at noon on September 25th of 2024. We will be sending out renewal communications in the near future. And, if folks have additional renewal related questions, feel free to get them submitted to the department and participate in the next virtual Q&A lunch. So thank you everybody for your participation and look forward to talking to you next time.